So hello everyone, and thank you very much for joining Quantum Business Law's webinar on October 19th, entitled Issues Often Overlooked in Canadian and Estate Planning and Tax Planning. And so at this point, I will take a minute just to introduce the speakers that we have hosting this webinar today. And so firstly, we have Todd Louie, who serves as a senior partner of Quantum Business Law. And Todd, for the last 20 years, has been involved with lecturing across Canada on international tax planning issues, corporate reorganizations, as well as estate planning. He has spoken to bodies such as the Ontario Bar Association, as well as various other professional associations here in Canada, as well as Ontario. Secondly, I would like to introduce Diane Everett, who is a guest lecturer that has kindly joined us today. And Diane serves as the Vice President of Planning Services at PPI Advisory. And she has been called to the bar both in British Columbia as well as in Ontario. And she practices in areas such as corporate reorganizations, shareholder matters, foreign affiliate taxation, and the taxation of life insurance. And so she is also a frequent speaker on taxation, estate law, and life insurance planning matters here in Canada. She's spoken to associations such as STEP, the Canadian Tax Foundation, and the Conference for Advanced Life Underwriting. Thirdly, we have Andy Yip, who serves as a senior tax lawyer at Quantum Business Law. His core areas of expertise are within corporate reorganizations, as well as corporate law. Last, we have myself, and I serve as a partner at Quantum Family Offices. My main areas of practice are estate planning and financial planning. And so as for the main speaking areas that we have today, that will include the basics of estate planning, all you need to know. Second topic will be how to create a tax-effective corporate structures. The third topic will be achieving superior asset protection. The fourth will be succession planning for family businesses. And the final will be how to provide for adult children and family members that are not involved with a family business.
Maybe I'll take it from here, Jordan, if that's all right.
Sure, that sounds good.
I'd like to, first of all, welcome everyone back. I know there's a wide variety of advisors, lawyers, accountants, business owners, wealth advisors, insurance people, things like that. So we're very happy to have everyone in attendance. Of course, we don't want to be remiss in not mentioning business owners. Get a lot of phone calls and emails from individuals who have attended past webinars and previously in-person seminars. And one of the questions that I've had recently was from an estate lawyer who attended an event that we had hosted. And he mentioned that one of the sessions I did for estate lawyers dealt with the question about, are you looking under the shares? And he said, you've really perplexed me. I still don't know what you mean about looking under the shares. So this all relates to distinguishing and differentiating estate planning from what I would call tax-effective estate planning. In speaking with many estate lawyers, I find that the biggest focus on providing for the tax-efficient transfer of assets to the next generation involves the preparation of wills. And of course, there's really no single item that's more important in estate planning, I don't think, than a will, but certainly it doesn't stop there. What I'd suggest is the best answer to the question that this gentleman presented to me is to understand the breadth of the implications, the tax implications, the cost to the estate, the cost to the family, for not doing proper, or I should say, proper tax-effective estate planning. Now, whose responsibility is it, was the question that I asked this gentleman, and he said, well, I think it's the responsibility of the accountant. What was the question, though? The question was, are you looking under the shares? Are you looking at the assets, say the trial balance of a company? Financial statement may demonstrate that there's certain problems. There could be excessive amounts of cash. There could be loans to related parties. There could be investments or, in subsidiaries outside of Canada, all of which present their own unique tax problem. And to the extent that an estate lawyer is charged with that responsibility, I would argue that all professionals who are involved have a joint responsibility. And when you're looking to give advice on how to most effectively transfer the assets with the least amount of tax implications at all, well, I think it's important to consider some of these really critical issues. Well, what is really behind all of this? Well, let's take a step back. And I'm going to say that we've had clients that have had assets in excess of $100 million, and no one ever told them that when they die, the shares of their corporations are treated as if they've been sold, as well as other assets, by the way. 70(5) of the Income Tax Act states that when we die, our assets are deemed to have been disposed. A deemed disposition occurs. Although the assets have not really been disposed of or sold, they've been deemed to have been, therefore triggering capital gains taxes and significant costs and expenses that in some cases can be avoided. So what are those issues really about? And this platform today is going to be designed to provide a spontaneous, interactive exchange of ideas amongst the experts on our panel who have decades of experience in some cases. Some of us do. Some of us aren't old enough to have decades of experience, but still good experience nonetheless. But we're going to be talking about the implications of liquid assets that are held within a corporation or near liquid assets. In some cases, it causes the loss of capital gains exemptions. Much effort and attention has been given by some of the people in attendance to determine how they can multiply the lifetime capital gains exemption. And sometimes there is no capital gains exemption whatsoever. And 10 times 0 is still, you guessed it, it's 0, right? And we'll just be discussing that a little bit later. Some of you may find that a little bit alarming, but no need to be alarmed because there are solutions that you can take advantage of that can remedy this and other problems. One of the other issues is, when an estate lawyer is looking at providing for assets being bequeathed to the next generation, are you really looking at the tax cost of the shares and trying to determine the true liability? And is there any opportunity to effect an estate freeze? And at what point does that happen? We'll be talking about estate freezes a little bit later on today. There's also ways of reducing the effects of tax on death that we're going to be discussing, and also while you're alive, which is the good news. Secondly, we're going to be dealing with methods of allocating corporate assets in order to achieve better results. So from this point of view, we'd like to get into our discussion. Diane, I think you have something you wanted to add to that.
No, I was just clearing my throat. I'm sorry, and I apologize.
I'm dying to hear what you have to say. Not at all. All right, so essentially what I'm suggesting to you before we go any further, and I'll just put this before our panel to kick our discussion off. Oftentimes when we come up with estate planning strategies and techniques on how to, fund capital gains taxes and how to equalize estate, sometimes you have kids that are in the business, sometimes children are not, and we want to be able to treat them all equally. But sometimes their contributions are different. In other words, one child might work 7 days a week, 12 hours a day in the business. Another kid may be a physician and have his own life. And you want to be able to determine how those things are dealt with. We're going to be getting into that. But one of the things that we often see is people saying, oh, what is the cost to do these things? But in reality, if you have liquid or near liquid assets inside of a corporation, most often it doesn't mean it's costing you anything. What it means is you're repositioning assets inside of a corporation in order to get a far superior result. And that's one of the fundamental premises of tax effective estate planning, is how to position the assets. It might mean that you're moving them into a certain kind of instrument in order to achieve tax sheltering. Well, the cost of doing that, providing it doesn't come out of the company, does not include any income attributed to you personally in most cases. So through this discussion, we're going to be talking about some very interesting ways that your family businesses can benefit in a variety of different ways. So Jordan, maybe we could have a look at the first slide. Could we, please?
Yes, this is the first slide, estate planning.
Oh, it's right in front of my eyes. How about that? All right. So let's talk first about corporate structures. whether, so this is, let's go on to the next slide for a minute. Sorry. The next slide is the one I thought we were going to look at. I apologize. Oh, all right. It appears as though this is the one we're going to talk about. We'll stay with this one. So creating tax-effective corporate structures. I mean, I'm going to kick off this idea by saying that in some cases, an opco and a holdco is simply not enough. Andy, I'm wondering if you could make some comments as to why standard opco holdco structure might be problematic.
One of the biggest issue with that structure is that you have no way of getting out non-active assets within those companies unless you distribute them to the shareholders personally, which would be a taxable event. So to access individual lifetime capital gains exemption quota, the underlying corporation has to be a qualified small business corporation. In other words, it has to be at least 50% active, or the assets have to constitute 50% of fair market value of all the assets within the company for 24 months before the disposition. And at the time of disposition, has to be 90% active. In a like holdco opco structure, typically the shareholder will be remiss and forget about those non-active assets, and well, thereby disqualifying them from access to lifetime capital gains exemption.
Yeah, so going back to this whole idea, about tax-effective estate planning, how often do we see that as the entire solution to create asset protection? Relying upon limited liability protection of a corporation is fine, but what about at the shareholder level? What about the fact that an individual who is a shareholder may well have a claim against him? He may well get sued.
Well,
Diane, what would you? Yeah, please, Diane.
Yeah, Section 160 can be troublesome. Section 160 of the Tax Act. And I just point out to you, there was a case about 3 or 4 days ago in the Tax Court of Canada, the Murphy case, which talked about dividends that were reputedly or reportedly paid in consideration of management services rendered to a company. What it does is, without getting into all the details, and the case is interesting because it reaffirms the Newman decision from, I think, around 1999 or 2000 in the Supreme Court, that a dividend isn't property. The key point to realize in all of this is that transferring, say, retained earnings from opco to holdco isn't the end of the story. It could be that there's, a long tail of liabilities, perhaps at the opco level, perhaps even at the shareholder level, that can undo all of that. But can I step back a second, though? And I really want to just ask you one question. What's your experience? I gave a presentation to the Halifax Estate Planning Council the day before yesterday. And one of the things I talked about, and I'm equally guilty of this in my practice, and I've done this in the past, is I've often neglected, for example, to talk about charitable giving. But it's not just that point. The question really is, and I asked the participants, is how difficult is it to get clients to address the whole estate planning issue? You've got busy entrepreneurs, you have perhaps disengaged family members, you may have others who really, aren't part and parcel of your business. And I'm reminded of, somebody talking to me one time about pillow talk. How often have you seen that the spouse or significant other of a shareholder is really not engaged in the process, and they say to the significant shareholder, well, look, what about the kids? Well, it's really not factored in. So I would put that out as a starting point. How do we engage people to speak about the issues? Because we know we have answers. We know we have processes, which we're going to talk about. But I think that's a fundamental point to get to. And I struggle with it all the time. And I throw it out to you.
Mm-hmm. Well, those are very insightful comments, Diane. I take it a step further and say that if that is your entire structure, an opco holdco structure, then I would venture to say that going out on a limb that there's been very limited tax planning achieved within your corporate structure normally. I want to qualify one thing, and maybe just a comment that Andy made, and that is that this structure, if there's assets that are pushed up by way of an intercorporate dividend, could constitute lack of eligibility for the capital gains exemptions or for qualified small business corporation status of the shares. But the operative word is could. in situations where an estate freeze has been previously affected and you pushed up common shares to a holding company, that may not necessarily be the case. You may be restricted to one capital gains exemption versus many in that structure. And therefore, you may be tainting the shares of a holding company where you could otherwise consider multiplying capital gains exemption. Why are we talking so much about capital gains exemptions? If your estate is worth $50 or $100 million, you might be saying, well, who cares? Well, at the end of the day, it does matter, because you might not have one or two capital gains exemptions. You may have a dozen or more. And at $1 million a pop, it's not bad. Well, they're less than that, but it's increasing every year, as you know. So the entire issue has to be based on several premises. One is anticipating the changing circumstances of life, being able to make adjustments as your life circumstances themselves change. And oftentimes when we set up structures, really, we set it up with the flexibility to be able to make adjustments. And one of the ways we could do that, well, a very simple way, is if we do an estate freeze, and we're going to define estate freezes shortly. But if we do an estate freeze, well, oftentimes we can thaw the freeze, undo the freeze. Sometimes what we'll do is we'll have a trust set up, and we'll talk about trusts in a minute. And in a fully discretionary trust, it can give the trustees a capability to decide who amongst the family members, generally the beneficiaries, are able to receive assets or distributions of dividends and so on. So these are things that can be made, decisions that can be made down the road, and it can also be used to equalize an estate in order to ensure that you're treating your family members in the way that you really want to. The very worst thing is to die intestate, to die without a will. I guess one of the things, we're not going to belabor that point too much, but I can tell you, I can think of several clients that have had an excess of $50 million of assets who do not have wills. And every time it happens, I'm a little shocked, but it's not my shock that matters. It's the family's shock when the entrepreneur dies and they find out he doesn't have a will. Well, if there's a common law spouse involved, well, there's no automatic entitlement without contesting the estate. And depending on the province that you live in, there's various different guidelines that would govern the percentage or the amount of assets that would automatically, go to even a spouse, and then also children. So you lose control of that. So we're suggesting that, please do not neglect wills. And by the way, those of you who haven't done wills, I'm going to suggest to you take this as an opportunity to do that. If you don't have two wills, you should be doing it anyway. But I find that when you go through a discussion with a planner and you're talking about all these tax matters, you're talking about the family members, you're describing them, it's helping you think about the matters, and you talk about the shares of your corporation, and you're told right there and then what the tax liability will be based on today's value. And that is a profound experience.
Todd and Andy, I have a question for you. Intestate succession. So many times, I've heard in my practice, well, I'm just going to roll my assets to my spouse on death. I'll have a spousal rollover and deferred tax till the second death. Yeah. Typically, though, if you're intestate, only a portion of your estate rolls over. And just how problematic do you think that is?
It's very problematic. We had a situation not that long ago where there was a rollover of a portion of that, and in effect, in the province of Ontario, as an example, I believe it's 200,000 if my memory serves me correctly. I believe in British Columbia, Andy, I think it was 300,000. Was it not, or was it 4?
Around 3.
3, okay. And the balance going to the children. Well, that's pretty problematic. It really limits the spousal rollover. So in effect, you're relying upon a court-appointed executor or executrix who would have the capability to be in the power to be able to make a distribution. And that person might not agree with that. You might find that all kinds of problems come up when someone dies. Death brings out the worst in family members, not the best in many cases. So why have this exposure? Does that make sense, Diane?
Yeah, so at the end of the day, just to close that point, we not only have a tax issue because there are people for whom the rollover, spousal rollover won't work. So you've got an estate tax liability, or you've got a tax liability, pardon me, more properly. And on top of which, you have people potentially involved in the business who have no business, who really aren't ideal for it. I guess that's really what happens. So intestacy does have significant warts and wrinkles on it.
You know, we're talking about a lot of things. Jordan, maybe I'd call on you for a moment just to define an estate freeze for the audience. Because we're using that term a lot here now. It's starting to get even more a common word in our discussion. So please.
Sure, absolutely. So it's the act of enacting a share exchange, exchanging one's common shares for preferred shares for the purposes of capping or limiting the liability on capital gains taxes as the corporation shares grow. And so it enables a shareholder, essentially to limit the value of the corporation shares and to allocate the future growth of the corporation towards another body, such as a holding company, or in most cases, in our recommendations, we would recommend that the future growth of the corporation be passed along to a family trust with the shareholders' family members acting as beneficiaries.
All right, so before we go further, we're talking about all these different terms that you may or may not be overly familiar with. A lot of people know what trusts are, kind of. You know, there's a testamentary trust created by the will that comes into effect after you die, but there's also an inter vivos trust, a trust for the living. And I'm going to ask Andy to give a little more amplification on what a trust really is. But what I'd like you to understand before we go further is trusts are not aggressive planning. Trusts have been in common law for 900 years. First record, as a matter of fact, of a trust goes all the way back to ancient Rome. So in reality, we're talking about well-established laws and protections for family members. But Andy, maybe give some clarity to what a trust really does and how it's used, please.
Sure, Todd. In general, there are three main parties to a trust: the settlor, who contribute assets to formulate the trust; the trustees, who have fiduciary duties to the third parties, are the beneficiaries, to manage the trust and the assets within. And beneficiaries of the trust are the, individuals, or sometimes corporations or other entities that can receive assets or income distribution from the trust. And it's a useful tool as it can defer taxable events in some cases. For example, in the case that someone died intestate, if he or she had planned beforehand and transferred some of his assets or growth of his or her assets into a trust, then those the capital gains tax at death could be basically deferred until the deemed disposition of the trust at the 21st year, which could be subsequently deferred as well.
Yeah, I'd like to just talk about something. I keep hearing people telling me that, oh, my accountant, my lawyer, whoever advised me that estate freeze is not right for me. I'm too young. Company doesn't have enough value. The sales are too low. My kids are too young. There's a 21-year disposition rule, and I've got a kid who's only 2 years old. Therefore, he or she won't be in a position to receive the assets at the 21-year period. Well, I'm going to take a step back from that for a moment and say that most of these concerns that we're hearing are not well-founded. What I'm trying to say to you is that it's our belief, my belief, I should say, that estate freeze is something that should be done irrespective of age, irrespective of the age of the entrepreneur, irrespective of the age of a child. The only exception to that is someone who's quite aged, who may not necessarily live long enough to see an appreciation in the value. What you're doing is you're kicking the can down the road one generation with the anticipation that the next generation will do the same thing. So in effect, when we combine an estate freeze with a trust, and we're going to show you a diagram later about that, what you're really doing is you're creating an arrangement between you and your family members. And since it'll be a discretionary trust, maybe Diane, you could describe what a discretionary trust is, and how it would work, and what would be the powers of the trustee, and what would be the obligations to the beneficiaries.
Well, discretionary trust, let's concentrate on discretionary first. It suggests a series of options as opposed to mandated decisions. So you have a selection of choices if you choose to do it. So a discretionary trust means that the beneficiaries may or may not get some or all of the property, and that depends on a choice made by the trustee, hence the discretion. And at the end of the day, you can give everything to one beneficiary to the exclusion of the others. Might also add, we're going to pick this up a little later on, Todd. A lot of the discretionary beneficiaries of trusts include corporations currently in existence and corporations that can be incorporated in the future. And they're an integral part of this discretionary planning. But to think that you have something just because you're a beneficiary in a discretionary trust is wishful thinking. It's only yours once the discretion is exercised in your favor to pay you something, whether it's income or capital or both.
Yeah, perfect. Maybe Jordan, looking at the last point, how to provide for family members, most often children that are not in a family business versus the ones that are, how would you suggest the trust could be used, Jordan, in that context? The discretionary power of the trustees to provide distributions to beneficiaries.
Well, as the trust would be a discretionary one, they're able to have additional flexibility as to which beneficiaries would receive a rollout of the assets within the trust.
So in other words, you may decide to roll out shares of a corporation to the children who are in the business, and there may be other kinds of shares. Later, we'll talk about life insurance shares, and possibly we would have life insurance shares bequeathed to children who are not in the company, as an example. There can also be other ways of utilizing life insurance that we're going to be talking about. But the fact that there are planning techniques that make the whole process far more seamless and less costly in the long run is what we'll look at. Next slide, Jordan, please. It's not changing.
I believe it has changed.
Hasn't changed here. No, your wave.
I will.
Can you?
Are you able to see the screen?
Not really.
So maybe, sorry.
All right, I will share my screen. Might be better because you're having a technical issue with yours.
Yeah, I think we're having just a problem with.
Because I can't see the slides at all, regrettably.
Sure. So if you would like to share it, then.
Todd, I believe the slide that you wanted to pull up was how family businesses can be affected by certain events. And
Yeah,
I believe there were 5 or 6 speaking points, including dissolution of a marriage, et cetera, and so forth.
Okay, I do apologize. It looks like I've got it up now. I'm sorry for that. I believe the problem could be on my end, but I could not see the slides at all. So it looks like this is where we had covered these 2 issues. No, okay.
We've covered those issues, correct.
Right.
So
let's
I'm going to go ahead a couple of slides.
Yeah. Let's talk about minute books, first of all. We're talking about corporate structures, and I just want to make a point. There's so many situations where business owners are not maintaining minute books. There's a number of reasons why I believe it's important to do that. And in the event that you have, say, several corporations, maybe a dozen or more corporations, it becomes perhaps more important and more complicated, more difficult task. But it would be remiss for me not to make the point that we're talking about tax liabilities. Well, there's certain tax liabilities that could be encountered by not keeping proper books and records. There's a requirement under the Income Tax Act to keep books and records. And in this particular case, the kinds of information that exist within a minute book is information that may be required. If you were audited by CRA, they would often ask for to look at the minute book and to look at issues involving shareholders and directors and all of these things that are very important. There may also be a litigious situation that you get involved with, or perhaps there's shareholder disputes within a corporation. And the shareholder dispute might be related to some of the issues, such as the number of shares you happen to hold. Well, what evidence do you have that you actually do hold those shares? Ironically, we often see that shares are held by individuals other than the people who thought they were shareholders. Same with assets. When we do searches of real property, real estate, we find that the real estate is actually held by a different party than the business owner believed. So we're suggesting that this sort of thing really not be overlooked. You know, we've talked about the importance of asset protection a little bit, but I want to just go a little bit further into this whole thing. And I had mentioned at the beginning that asset protection is a very critical point. And one of the issues that I'd like everyone to consider is that you're fully exposed if you are the shareholder of a corporation and there has not been an estate freeze, insofar as the existing plus the future growth has a vulnerability to litigation that you really need to consider. What I think I'd like to do at this point is I'd like to talk a little bit about the general anti-avoidance rules, and maybe I'll give Andy to give some background on the GAR rules, please.
Sure. So there are three elements of the general anti-avoidance rule, or GAR. First of all, there needs to be a tax benefit. And second of all, there has to be avoidance transactions. And third, there will be misuse or abuse of the legislation. So basically, it's a tool of last resort for the CRA to challenge transaction of serious transaction where usually I suppose a taxpayer or a planner have planned a transaction to minimize their tax payable. And sometimes you can follow all the rules outside of the GAR and it still be fine under the ITA, but the CRA could use the GAR to challenge the transaction.
You know, when I think of GAR, I don't know about the rest of the panel members, but you know, I think of the Duke of Westminster, right? And I'm going to paraphrase Lord Tomlin's decision, and it goes something like this. And it's up to every man to order his affairs in a fashion where he pays the least amount of tax possible, even if it's unappreciated by the tax authorities and his fellow man. Something like that. Don't quote me exactly, but those are, I'm going to say, very encouraging words in a world that, you know, actually does make it very difficult in order to achieve certain types of tax planning benefits. So I think that the point of the Duke of Westminster is it is the background or the fabric on which our GAR system is really woven. And therefore, it is, there are three other criteria that Andy just mentioned, which is a case called Canada Trust Co. versus Her Majesty the Queen. And when you think about planning that's being done with or without trust, it's always important to consider whether or not the only reason you're doing it, or if the only bona fide purpose of what you're doing is to reduce tax or to avoid tax. Keep in mind that tax avoidance is not an offense. Tax evasion is a criminal offense. The problem that we have is that there is legislation that is very disconcerting. Case of Ottawa wine vaults versus McGuire is one that comes to mind. And in this particular case, the Supreme Court of Canada had rendered a decision a number of years ago, having the effect that an individual not only needs to consider his existing creditors, but he also needs to consider his future creditors. So this kind of legislation is somewhat disconcerting. The case of McGuire versus Ottawa wine vaults also deals with the Statute of Elizabeth, which is better known as the Fraudulent Conveyances Act. The Fraudulent Conveyances Act has the effect that if you attempt to hinder, to delay, or defraud a creditor, a court can make an award. And it does at times under the Family Law Act, where there's an equitable distribution of net family property. There are situations where wealthy families commonly have marital problems, and assets can come into challenge. So what we're looking to do is saying, how do we navigate this very, very winding road? I'd like to talk about asset protection within a life insurance policy. Perhaps, Diane, you could help us to understand what type of asset protection insurance can provide.
Well, life insurance contract at a very high level, any proceeds from the policy typically are immune from the life insureds or the policy owners' creditors where the beneficiaries are family members, basically members of a preferred class. And that is a very powerful protection against the claims of all creditors, including the Canada Revenue Agency. There are a number of cases recently. We've done presentations on this, which are fully 2-hour presentations, just because of all the ins and outs. And I think Todd, you and Andy and Jordan may have participated in some of them by my colleague Glenn Stevens. And I think the real key issue here is that insurance contracts not only provide an indemnity and immediate cash, but they also have an opportunity, properly done, to help you protect your assets from the claims of creditors.
Yeah, I'll take that a step further. I'll say there's the number of benefits that are not very commonly known by most people do include this preferred beneficiary class and the asset protection features, but there's also income tax benefits that are afforded by insurance. Diane, maybe you could talk a little bit about the tax benefits that insurance policies can, the Income Tax Act provides, yeah?
Well, the first thing is that a policy on death, policy proceeds are received by beneficiaries free of tax. That's the first thing. Individual gets it. You have $1 million policy, the life insured dies, the individual receives $1 million of cash. And it's free from the claims of the life insurance policy owners, creditors. The other one is a corporation that owns a policy will get a credit to its capital dividend account, equal to the difference between the policy proceeds and what's called the adjusted cost basis of the life insurance contract. And for those of you who are familiar with tax practice, it's not the same as adjusted cost base in subdivision C of the Tax Act, section 54, or 53 rather, pardon me, but rather is defined in 148.9 and is a separate calculation. So bottom line is that you can receive proceeds tax-free. You have an element of creditor protection as an individual. On the other hand, if the money flows into a corporation, it's eligible to be credited to its capital dividend account and distributed to its shareholders free of tax, which is a huge, in other words, if I had a dividend, an ineligible dividend be out to you, Todd, from your company, you'd pay tax about 47.7. With the capital dividend, you pay no tax at all. So that's the second thing is that properly used on death to acquire, to redeem, purchase, the shares of a deceased shareholder, something called, with postmortem planning, the 50% solution, the 100% solution, pipeline with CDA, sometimes something called roll and redeem, we can eliminate or reduce taxes very significantly over what they would have been, but for the insurance. And Todd, that comes back to one thing that I think is really important, is you want to make sure that you have the requisite powers in a will to allow an executor and trustee or a state administrator to make the appropriate elections and to do the proper planning to take advantage of that. So insurance does provide a number of very significant estate planning, asset planning, and tax advantages in the proper circumstances.
Yeah, thank you, Diane. When you're planning for the ultimate events in life, and it could be a liquidity event from selling a company, it could be issuing an IPO, going public, it could be death. It might be that you're intending to transfer your assets to the next generation during the time that you're alive. Well, it's important to understand that a transfer of assets, such as shares of a corporation, are deemed to be disposed of at fair market value, since the individuals you're transferring to are not at arm's length. These are individuals you're related to. And therefore, all of this planning requires very careful thought. What we're trying to do is trying to focus on things that get overlooked. Now, one of the other things, speaking of overlooked, that I want to mention is the need for shareholders' agreements within a family business. I'm astounded to find out how many family businesses we've spoke to do not have shareholders' agreements. And when we speak to some of the entrepreneurs, they say, oh, we don't need it because it's only family. Well, I'm going to give you a dozen reasons. That's simply not so.
Great.
How often do family members have disagreements? And at those times where there's a question, if everybody's in harmony all the time, well, then maybe you have less of a reason for a shareholders agreement. Having said that, that in the real world, that isn't how it goes. And there might be situations where there's, a stalemate, various different views. How are decisions best made? And by extension, what if a family member decides that he wants to sell his shares? Is he going to have the right? Well, guess what? Those shares are his property. If he wants to sell them and there's no agreement, what's going to stop him? What if he wants to pledge it as security to a bank? I mean, all these issues are really critical. And then what happens if the individual dies? Well, it's no different than any other two shareholders where the death of a business owner or a partner, a shareholder in a company may result in a need for funding to purchase those shares back from the spouse because maybe the spouse doesn't want to be in the business. There's all of the same reasons. So that's just one of the things I wanted to mention. Please don't overlook. So we'll move along, and we had talked about all of the issues on the screen here. We're going to move into the next area, and we're going to talk about succession planning for businesses. And one of the big things that we see, I think is, failure to consider who's going to be the successor. Oftentimes in family businesses, there's, several adult children that are working in a company, and no consideration has ever been made as what if something happened to the father, right? I guess we'll start off, from a point of view of financial losses. What kinds of financial losses? I'll open up to the panel at this point for comments on what kinds of financial losses occur at the death of an entrepreneur. Then we're going to talk about succession. So you're all invited to comment. Diane, maybe I'd call on you and say, what would be the typical kinds of losses that a business would incur at the loss of a key person?
Well, clearly there's the morale issue. The morale issue would manifest itself perhaps in a loss of business, loss of opportunities, loss of direction, perhaps, and I've seen this before, where a senior shareholder has passed away and the balance of the shareholders or perhaps employees have lost confidence in the remaining management. What does this all mean? It means that there should be a structure in place at a management level at the very least for continuity. And that continuity can also be reflected in a shareholder agreement. What are you going to do if somebody becomes disabled or somebody passes away? And those are not just economic issues. They're profound management issues. And there are a number of issues that have to be addressed in that, not the least of which is, do you buy them out? And if you buy them out, who's going to be the continuing management? Are you going to have a cross purchase? So in other words, maybe some voting powers will be concentrated in the hands of some other shareholder who can afford to buy them. Or is the company going to repurchase the shares, in which case you're going to have a proportionate increase in the equity of the remaining shareholders? Is that desirable? So those are just some of the issues. I mean, there are so many that go on. I might add, when we're talking about the death of a shareholder, that's pretty clear. What's the death of a shareholder? Well, they're defunct, they're gone. You could do a Monty Python skit on that. But when it comes to disability, what is a disability? I have seen, and I'm aware of one, my colleague Glenn Stevens shared this with me, that a shareholder who becomes mentally incapacitated must advise the board of such incapacity within 90 days for disability purposes. I mean, come on. How can you say that somebody's disabled, perhaps physically disabled? Well, you can have a heart attack and you can be back on the job in 10 days. Is that disability? So these are issues that I think are really important and are rife for dispute. And again, the shareholder agreements that we've seen in our shop on a number of occasions have been sent to us for review. Many are excellent. Some others need a little work. And it's death and disability, particularly disability, it's problematic.
Yeah, I think this is an important point. And just to amplify a little bit on what Diane said, I'm going to take it further and say the same kind of lack of confidence that might exist with employees toward a new individual taking over a business may also be extended to clients. It could be that the technical competency, even if it's not real, the perceived competency of the next generation may be insufficient.
It could be the bank too.
Sorry?
And it could be the bank too.
That was my next one. You stole my thunder.
I'm sorry. Because we reversed this.
No, I'm joking.
Reversals work, Todd. Reversals work.
Right? So the whole issue has to be anticipating the what ifs. So some things are not even what if, they're when. Well, it's not pleasant to think about, but all of us die. All of us at times become disabled, if not by an event, then by old age. So at the end of the day, these things are tantamount. These things are critical to consider and how we're going to protect against inevitable things. So I'm going to suggest to you that death and disability and critical illness, those kinds of things, are all things that are really at the forefront of estate planning, or really need to be. But the secondary issues to those can involve things, such as a marriage breakdown. And what kind of claim would that have? Well, there's certain things that can be done within the context of an estate freeze that can provide protection. And I'm going to suggest as well that sometimes we see situations where there's a family business where a spouse doesn't necessarily sue her own spouse. And the reason for that is because the spouse is involved in a family business and he doesn't actually own any shares. And how does an entrepreneur protect themselves in light of, as an example, the Statute of Elizabeth or McGuire versus Ottawa Wine Vaults, considering who a future creditor can be? So sometimes what we do is we look at ways that we can achieve benefits that we're going to talk about a little bit later. We're talking about integrated solutions that combine the capability to limit, cap, or freeze the value of your shares in your hands, to introduce family members directly or indirectly, create purification to be able to move excess cash, because Andy mentioned earlier, he defined the eligibility criteria for the lifetime capital gains exemption as all or substantially all of the assets must be actively used in the business at the time a person dies. Otherwise, you don't have a capital gains exemption. Same when you sell a business. And also there's the anti-stacking rules. If you have the OpCo-HoldCo structure, well, the anti-stacking rules provide that for a 24-month period, you have to meet that very, very high standard, 90% of assets. So when we're talking about estate lawyers who are doing estate planning, here's the answer. I'm sorry it's so long to get to it, but these are the things that estate lawyers, corporate lawyers, accountants, advisors, insurance people, wealth managers all need to be considered. It's a joint responsibility. If you're putting a large investment in a holding company, and you're not taking these things into account, you are causing harm. You are causing the loss of very, very important tax benefits for clients. And the client won't know. He'll just happen to put his money into a holding company. Maybe it's a large life insurance policy with cash surrender value, and it goes into a holding company. How many times have we seen that? The process of correcting that is called corporate purification. One of the strategies we often do are butterfly strategies, which involve the separation of these assets. It's better that it didn't happen to begin with, but these are all very key things that are needed. And that is sometimes used for cash, it's sometimes used for, moving out shares of companies that hold investments. Sometimes they're foreign subsidiaries that have to be separated. Sometimes we move an active business. There's a lot of different things and tools that need to be done, but all of it needs to be governed by the family's objectives and what the family's attempting to achieve. So these are all part and parcel of things that are all too often ignored that we would like you to really focus on.
Can I just make one quick comment about that, about two emerging practice areas, two troubling spots that we're seeing in the whole estate planning area. Number one, my office gets at least 5 to 10 calls a week on businesses that are being sold where the companies own life insurance contracts. The exiting shareholder wants to get that policy. It's difficult to get them out of the companies. And it has to be done very carefully. It's not just something you can do and assume that there will be no repercussions. we've seen cases where it been significant corporate and personal shareholder tax liabilities arising from handling that incorrectly. That's the first thing. Now that's just at the corporate level. Forget that for a second. But the second one that we're seeing, and there are an awful lot of cases out there, particularly starting out in BC, but we're seeing them in Ontario too, is that where parents, often aging parents, put assets into the joint names of them and a child, perhaps one of 3 or 4 siblings, the presumption of resulting trust cases are all over the place now and require some really careful consideration, if for nothing else, where you have a parent wanting to do that. That calls for estate planning and wills planning, and also very good documentation about what the intention was. So again, you know, the whole estate planning and planning process can be brought in quite inadvertently, where the failure to do it, the failure to plan, can be just a glaring error and omission. I just mentioned that.
Good point, Diane. I mean, how often do we have, you know, the value of a life insurance policy looked at as the cash surrender value? And in some cases, correct me if I'm wrong, but I don't believe that the value of a life insurance policy is necessarily determined by the cash surrender value.
Well, when you transfer, let's say you had you have a company and you're selling it. You have a policy in it. The policy is, say, 20 years old, and it has no cash surrender value. Let's just think that. And you transfer it out to yourself. Well, for tax purposes, the company will have nominal proceeds of disposition. But you, as a shareholder, will have a huge shareholder benefit under Section 15 of the Act, equal to the fair market value of the policy. And you say, well, yeah, but it's like a term policy, or it's a policy without cash value. It doesn't matter. It's what the fair market value on an actuarial basis would be at the time of the transfer. So there might not be any tax on the company on the way out because there's no CSV, but it sure has a big value to you as a shareholder. Otherwise, why wouldn't you just leave it in there and let it lapse?
Yeah.
If it didn't have value. I mean, just sort of a practical matter.
Yeah, you'd leave it behind.
Yeah, are you going to do that? Not if you're uninsurable, you aren't.
Yeah. So those of you that have investments inside of corporations, you need to really take heed, whether it's an insurance policy, and as Diane's pointing out, even a term insurance policy that has no cash surrender value whatsoever. There's a benefit conferred upon the shareholder. And clearly, it's exposure that you don't need. So when insurance policies are being set up or investments are being set up within corporations, it's important to use the right company. It's not that a corporation cannot be used correctly and effectively, but it has to be the right company. And it's not necessarily the holding company. It might be a sister company, right? Anyway, let's move forward. Right? Oh, before we do, let's talk a little bit about, you know, just this whole concept of educating the next generation. This is something that's a complicated issue. An analysis has to be done, and also family members need to be also educated on how to handle family wealth. I can't move forward without saying that. There's all too often mismanagement, not only of businesses, but of assets, because the next generation has no training on handling family wealth, right? So we can also talk about funding taxes, and now we're going to get into an actual illustration on how this will work. And I'm going to turn this over to the panel in just a moment. But before I do, I'd like to just talk about what all this means. Well, at the end of the day, we have a situation here where we have a very successful active business called OpCo, an operating company. And of course, in this particular case, we have the shares held by a holding company. And what I would generally suggest is that this is the company that we've been talking about a lot. We've been talking about the fact that the assets, the combined assets between the OpCo and the HoldCo must be all or substantially used in the active business domestically in Canada, or there is no capital gains exemption. Part of the benefit that we might be able to derive is a purification strategy, which can result in these arrows, which demonstrate a tax-free intercorporate dividend that would be paid from the operating company up to the holding company under Section 112(1) of the Income Tax Act, providing a deduction for the capital dividend. Sorry, for the tax-free intercorporate dividend. then the trust is not really a flow through, but it acts like a flow through, meaning we can separate active assets from non-active assets. So we can put all of your investments in Invesco, but you don't want them in Holdco. And sometimes what we do as far as benefits, we look at control issues. And one of the things we take into account is the law in Canada, such as the Fraudulent Conveyances Act and some of the case law that we've been talking about and trying to determine whether or not this is the very best place to achieve asset protection. We sometimes go to jurisdictions such as Barbados, New Zealand, UK. Sometimes we look to jurisdictions such as Wyoming, Nebraska, Alaska, and other places that might be good asset protection jurisdictions. Now, one of the issues with GAR, General Anti-Avoidance Rules, is we have to be careful that what we do doesn't offend these rules. And there's actually new rules in Budget 2022. There's the substantive CCPC rules that have been put into place, and mostly to deal with artificiality, continuances of companies from Canada to other places, other countries, and artificially saying, well, this is a foreign controlled company or a foreign corporation. Therefore, ending up in a situation where people are making a very bad attempt in order to reduce tax on passive income and to reduce capital gains. Well, one of the things that we sometimes do is we set up trusts very legitimately in countries that have superior asset protection regulations and laws. Therefore, moving outside of Canada for that purpose, and also taking into account a plethora of other benefits and intentions and purposes that we're looking to do. And oftentimes it results in very, very large benefits as a natural consequence of the planning that we're doing, not a purpose of what's being done. Consequently, we also look to life insurance for the reasons that Diane described. Diane described that a life insurance policy has no tax on the death benefit. On death, there's a capital dividend account that's been created. There's no annual accrual taxation on the investments going inside of the life insurance policy. If you compare that to investment income in the province of Ontario at 50.17% on passive income, 26.5% if it's a general rate tax, well, no tax is much better than either one, isn't it? So essentially what we're looking to do here is to achieve certain benefits. One of the things we're doing is we're determining mathematically what is the capital gains tax when we do the freeze. So you notice the entrepreneur is frozen. It says entrepreneur freeze. All of these shares are frozen at a certain value. We can put an insurance policy into place, or we can use after-tax corporate dollars to fund that policy at a tremendous discount. And then what happens is you have the growth of the policy tax-free. Essentially, you can use the funds in order to provide for key man needs. So Diane was talking about what happens when employees lose confidence in a company or the bank or perhaps clients and so on. Well, at that point in time, there's going to be a financial loss to the company, a disruption. You can use that to hire a replacement individual. And you can also use it for personal benefits. Maybe Jordan, I'll just have you describe the diagram on the right side, and we'll open it up to the rest of the panel as well. But why don't you describe, Jordan, what is happening here? We've talked about purification of a company to create eligibility for the capital gains exemption. We've talked about creditor proofing. Now we're talking about what's in it for the entrepreneur while he's alive. Maybe you could explain it.
Yeah, sure, absolutely. I'd say really one of the main sort of objectives of a shareholder after they've done an estate freeze and set up this type of structure with an Investco that's held by a family trust. They've safely moved the assets so that they're not affecting eligibility for the capital gains exemption. But the question is now, like, how can they personally access these funds at a tax reduced basis? I think that's a question that we see very often. And so the structure that we have illustrated here then would be first the insured company then purchasing a permanent cash surrender value life insurance policy, which would be either a universal life insurance policy or a whole life insurance policy. And alternatively, there's also hybrid products that have really benefits of both universal life insurance policies as well as whole life policies. But within this illustration itself, then, the shareholder would be seeking a loan from a financial institution that would be roughly equivalent to the premium that we paid out every single year towards a life insurance policy. And so the premium amount can really be any amount starting at a minimum of about $50,000 per year. So the insured company would then pay $50,000 or more towards life insurance policy. From there, the life insurance policy, its cash surrender value and its death benefit would then be pledged as a collateral assignment towards that bank. And so in return, the bank would then issue a loan that would be equivalent to the premium that was paid. So let's just say it was $50,000, for example. Then the entrepreneur would receive that $50,000 shortly after making that premium payment from the insureco every single year from the financial institution. There is one requirement, though, that is done to ensure compliance with these structures. And so that would require that the entrepreneur then pay a guarantor fee, which in our studies and our consultations is generally held to be about 1.5% then of the loan of the loan amount that's being received by the entrepreneur. So that guarantor fee will be paid towards the corporation holding the life insurance policy. Otherwise, using this type of corporate asset to secure financing would oftentimes result in a benefit to the shareholder, a shareholder benefit. And Diane, I think I was wondering if you'd like to shed some additional light on the guarantor fee that would be required for these type of structures.
Well, the guarantor fee, like you said, Jordan, is meant to eliminate an argument by the CRA that insureco has conferred a benefit on a shareholder or a person basically related to the shareholder. And so that helps protect against that possible reassessment. Can I just make one quick point about the structure here with insureco? Is that, you know, when you have insureco, it's a beneficiary of the trust. You remember when at the beginning we talked about it being a discretionary beneficiary? You know, they're the individuals and the corporation. Well, insureco is one of those discretionary beneficiaries. And what we like to see is to move dividends up the holdco to the trust and then through to insureco. And insureco will then get the 112(1) deduction and use those amounts to fund the policy. So effectively, instead of having the policy in holdco, where it has been in many cases, when you come to sell holdco, you have to get rid of the policy somehow, and that can be taxable to both the company and the individual, the shareholder. Here, by having a cross insureco, you're not going to sell insureco, you're going to sell holdco. So you don't have a problem of transferring the asset, and if the policy has any cash values, it doesn't throw you offside your QSBC testing. So you get the best of both worlds.
Yeah,
so I do know in our shop we've probably got over 1,000 of these running over the past 15, 20 years of these insured programs. Some through insurecos, some not, but it depends on the structure.
Sure. Thank you for that. So I'd say I just wanted to explain some of the brief benefits then of the solution, as we don't have much time. We're just past the 1 o'clock mark. So I mean, the main benefit of the life insurance policy, and I mean the main purpose of it is really to be able to cover some of the capital gains tax liability, right, as well as the liability of replacing the key person of the right, operating company upon their death. So that's the right, the main intent of the death benefit provided by this life insurance policy.
Sorry,
the leveraging strategy that we have here, it's primarily meant to supplement the cash flow of the shareholder, and so there would be no tax on the receiving of the loan from the bank. And so oftentimes for shareholders that are taking large dividends from their corporation every single year, this is an alternative payment structure for that shareholder that also funds a life insurance strategy.
Correct.
So
exactly.
Thank you very much. Just in closing here, what we're doing is we're offering an opportunity for you lawyers and accountants to have a role in our family office where your clients that are not necessarily getting this full scope of services can benefit from you being involved as part of the solution. And for you business owners in attendance, well, your accountants and lawyers are certainly welcome to participate in the Quantum Family Office. Essentially, there are a number of areas that are often overlooked. Oftentimes when there's a steps memo that's written by an accountant to a corporate lawyer, corporate lawyer might start following that and may not necessarily be trained in the tax implications. Oftentimes, the accountants on the right side, or on the top rather, are not necessarily trained in legal structures. So being able to navigate the use of trusts, as an example, is a very important thing, and to do that effectively, looking at purification issues and state freezes, advanced well planning, or what I would call tax effective well planning, looking at insurance strategies that have been talked about today, as well as wealth management. And the final area that we are often look at, because we're always interested in protecting the assets, always interested in protecting the shares of the corporation. Well, what about what's underneath the shares in another way? Well, oftentimes there's digital assets, and our group is involved with the former head of IT for the IDF, the Israeli Defense Forces, and a joint venture we have with this particular group. We're able to provide solutions that are not common or arguably not available in Canada. They give a very, very different way of looking at how to protect assets. So in other words, we're protecting the shares, and what's under the shares is an active business, and what's within the active business is vulnerability to a cyber attack, which could be a random attack, it could be a targeted attack, it could result in loss of critical assets. And it's a matter of marrying together technology with the understanding of business processes. And this is something else that's available. So really, all of these items we're talking about here are issues that are really most often left out. And the family office is intended to provide this multidiscipline approach, given the fact that we are admitting lawyers and accountants with their clients who are coming into the family office and being part of the process to resolve the solution. Also, financial advisors, life insurance agents are also involved, as well as wealth managers, who we give a seat at the family office on the advisory table, and being part of this delivering these solutions that otherwise may not be that available. So we'd like to thank everyone very much for attending today. We appreciate all of the input by the expert panel, Diane and Andy and Jordan, and we look forward to meeting you again, hopefully very soon. Jordan, what is the date of the next program? I believe it's November.
Yeah, that would have to be determined. I think that we'll say
I think it's the 16th. I think it is the 16th. So we'll confirm that to everyone by email.
There were a few questions in the chat, actually.
Oh,
so
sorry.
I think if you
Please
take a few moments just to be able to answer some of them.
Yeah. Go ahead, Jordan.
Sure. So if you want me to read out the first question, then. So this is from Michelle. Michelle is asking, is a trust important if the individual only has one spouse and one child, with a will that transfers everything to that child?
The issue is not only a question of to whom the assets are transferred. At times, it may be that there is certain tax effectiveness in having beneficiaries named, and if the only beneficiary is a child, well, I'd suggest that it might cover future children, it might cover future grandchildren unborn, depending on the age of the child. But typically, there's a capability to do. A child may not be in a position to receive assets, and he may marry badly, or she may marry badly. And being a beneficiary of a discretionary trust does not represent an automatic entitlement in family law. So I would suggest that giving shares to an adult child directly, or a young adult child in particular, might not necessarily be the best thing to do. So sure. In other words, it can be there's a mandate of the Family Law Act and Family Law Court in the province of Ontario and other provinces is to achieve an equitable distribution of net family property. And to the extent that there's a beneficiary designation, as I mentioned, you may not necessarily be so susceptible to those kinds of problems and others. But the answer is a trust is a good idea for anyone.
Sure. And just one more question then from Munira. Munira is asking, if a corporation pays annual insurance premiums for individual policies for the entrepreneur, is it taxable to the shareholders as a shareholder benefit? And so I guess that question could be answered by Diane.
Yeah, typically, if you have the company pay something for you, that can either be a shareholder or an employee benefit, depending on how it's done. In either case, make sure that you speak with with the accounting manager for your particular firm before you do that, because it might be a T4 amount, might be a T4A amount, or it might be payment of an existing shareholder loan. So there's a lot of ways of dealing with that one. So generally speaking, start from the proposition that yes, it's taxable, then try and figure out a way to minimize it.
Yeah, one thing I'll just maybe comment on, and that is that I think it would be depending on who the beneficiary of the policy is. So as an example, so say, Diane, as an example, that a corporation buys a life insurance policy for an entrepreneur, and the corporation is not only the owner, but the beneficiary of the policy. That would change that scenario, wouldn't it?
Right. Well, there's no benefit because it's a corporate asset. Nothing's being conferred on the shareholder, right?
Correct. Now, take that a little bit further, and whoever receives the shares of the corporation on death of the entrepreneur would then be entitled to, under subject to limits, a capital dividend account, which is created at the time the death benefit's paid out and is paid on the shares to that individual. Also, the use of life insurance shares can be used. And these are shares that essentially are issued at a nominal value before you buy a life insurance policy in a corporation.
You can do it after too.
Yeah, the benefit, I guess, Diane, is it not, if you do it before, wouldn't it be that you'd have a nominal cost base on the shares? If you bought a policy and the policy had value, would it
in the corporation?
Yes.
Yeah, well, typically what it does is it has a cost basis that's determined by the insurance company. Typically, that's the sum of the premiums less what's called the net cost of pure insurance. But assuming that it's nominal, the company, when the person dies, the company receives insurance policy proceeds. Those are credited to its capital dividend account, and dividends can be paid out to the shareholders, the new shareholders, as tax-free capital dividends, done all the time.
Yeah, perfect. So we could resolve those issues for you, and some of them aren't that simple, as you can see. There's a question by Khaled I'm seeing here. What's the impact of Section 55 on corporate business? Yeah.
That's an important one. And Khaled, what you're referring to is the issue around safe income. And if a dividend is paid, an intercorporate dividend is paid, and you don't have sufficient safe income, which I won't get into for right this moment, there's insufficient safe income to pay the dividend, then the dividend will be treated as a capital gain in the hands of the recipient corporation. So you don't get the deduction. Sometimes, however, we try and do that deliberately, particularly in the whole area of surplus stripping, which is a different topic altogether. So Section 55 can be problematic, but you have to make sure that when you pay a dividend from OpCo to HoldCo, and you want to get it over to InsureCo, or even for that matter for Investco, if it's a beneficiary of the trust, you want it to come out of safe income. If it comes out of safe income, Section 55 is not an issue, unless there's some anti-avoidance rule that kicks in.
Yeah,
there's also another comment in there, and when we were talking about Section 55, there's a question: why does the trust need money from the bank? It's not the trust needs money from the bank. What's happening is, and I think what you're referring to, is that InsureCo owns the policy, which is paid for by intercorporate dividends. It now has an asset. It takes that asset and gives it to the bank for a loan to the shareholder of InsureCo, Investco, even OpCo or HoldCo if it wants. And that has nothing to do with the trust. It's just that the trust is simply the conduit for getting the cash into InsureCo with which to pay the premium. And that premium goes into the policy, and that's used to secure the debt. So the trust is only very indirectly involved in this, and it has nothing to do with the bank.
I just maybe further a comment in relation to the challenges presented by Section 55. Section 55(2) of the Income Tax Act deals with anti-avoidance issues, and there are several. Some of them have been overcome by, at least one of them by Bill C-208, but I'll go a little further and just talk about the whole notion of safe income. Well, the interesting thing is where Section 55(3) applies, 55(2) does not apply. What does that mean? That means that if we're dealing with moving assets from within a corporation that is not safe income, it can be achieved through a 55(3)(a) related party butterfly, which we do a lot of, by the way. So it's not as though, I agree 100% with Diane, but it's not as though there isn't another way to approach this, so you're not going to get caught. The concern that a lot of people have is the purpose test. And the purpose test states that if the purpose of paying the dividend is to decrease the fair market value of the shares or increase the tax cost, well then, as Diane mentioned, then the dividend would be converted into a tax-free dividend, would be converted into a taxable capital gain. So in the OpCo holdco structure, we see it all the time, where people aren't really doing these things. I don't know if those of you in the audience today are doing safe income calculations. I think it's a pretty good practice. But more importantly, I think what we need to consider is a dividend policy. The attribution rules in 74.4 have a very broad wording, and it's our concern, or my concern, that in some cases CRA may decide to use that wording where you have a trust, including a beneficiary, and the fact that we've done a freeze. Well, it could well be that the growth could be attributed, even though it was never given to the trust, because the beneficiary being a spouse, because of the fact that it's fully discretionary. Well, it could be, the income could be attributed back to the entrepreneur, or the additional value, I should say. So what we're getting at is you've got to have someone looking at your financial statements at the time when the accountant, if you are an accountant, you're delivering it, look at the intercorporate loans, look at the dividend policy, determine how much cash the company needs, don't let it go past that amount, create conduits to move the money. You've got to have a process that contemplates these issues. And this isn't the kind of stuff that, it's not even accounting that we're talking about. This is tax law. This is, accounting's over here somewhere, tax law is over here, and sure there's an overlap, but this is the far right side. Farthest diametrically opposed issue to accounting that I could think of. But accountants are handling it, right? Yeah, sorry.
But I think the key thing is you mentioned Section 84. You mentioned Bill C-208, Section 84.1, which allows for some more creative ways of interfamily succession, intergenerational succession planning. But, there are lots of times where, you do a related party 55(3)(a) butterfly transaction, repurchase shares. It makes me think too that when we do our planning, Todd, and this is your point, I think, and it's one we've got to keep in mind, sometimes we do want a capital gain in there.
Absolutely.
And sometimes that cost is very nominal by compared to, let's say, I've done intercorporate dividends where I wound up with a capital gain because I wanted to. My net cost to the shareholders is about 27.5%, as opposed to 47.7% on a dividend. So sometimes we tend to think, okay, how do we avoid this issue? Well, sometimes you don't want to. And that just depends on your cash flow. And that's your point. And I agree with you 100%. That's what you got to sit down and talk about.
Yeah, it's understanding what's important to the taxpayer, what's important to the client, what's important to the family's objectives, and navigating this very, very winding road, and utilizing the advisors in the family office that are known and trusted, right? Not that we're not known and trusted, we hope we are. But the point is that your own accountant knows your situation really well. Your own lawyers know your situation well. And financial advisors, insurance people. The other point about Bill C-208, okay, first of all, for family businesses, it's a long overdue change. I think it's amazing, the fact that we can look at utilizing capital gains exemptions on the sale of shares when an individual legitimately retires. And I wasn't a fan of what people were doing a year ago or so or more, where they were jumping on this bandwagon saying, oh, there's this loophole. I said, what about GAR? They said, doesn't matter, sign here. I'm saying, no, it doesn't work, right? Because of the fact that the reason people were doing it, you have a 40-year-old business owner, and you've got a 20-year-old son, and you're transferring the company, and the 20-year-old son doesn't even work in the company because I'm sorry, but that does not work. Anything that's artificial, anything that's an abuse or misuse of the legislation, I've always been opposed of. And I've made that very clear. Now, one of the issues, second issue of Bill C-208, of course, is siblings are, I think this is one of the greatest features of the new legislation, but siblings are no longer deemed not to be related for purposes of a single-winged butterfly. And where you have two siblings in a company that control the shares of that company, we can now achieve these very, very, I mean, I can't even imagine doing proper tax planning without a single-winged butterfly. To me, double-winged butterflies are great when they're needed and they have their place, but a single-wing 55-3A is essential in order to, I've seen situations where a guy had $80 million stuck inside of a company. His accountant and lawyer said, oh, don't worry, we have a plan. Accountant whispered in my ear as we're sitting around the table waiting for the business owner to come in and the rest of the family, and says, here's what we're going to do. We're going to set up a new company, move all the clients, because we want to preserve the $80 million. I said, well, what are you going to do about the taxable? This is what taxable event? And I said, you just said you're going to move all the clients. He said, we're not moving assets, we're only moving clients. And I said, well, have you ever been involved in a business valuation? Have you ever, right? Have you ever done, I said, look, think about it. I want you to think about it, please. He says, you know something, you're right. I never thought of it, right? A taxable event was being triggered at the advice of his trusted experts because the important nuances are not being looked at closely. There's really nothing more important. And being able to prevent this silo operation where accountants, lawyers, insurance advisors, financial advisors, all operating independently, autonomously, and nobody's looking at some of these very critical things we're talking about today. So that's kind of why we're passionate about this, because I don't like having to help a taxpayer who calls me and says, well, I've got a dispute with CRA. Okay, fine, no problem. We'll file a notice of objection. 90 days later, we'll file a notice of appeal to tax court. We'll resolve the matter with the Department of Justice or not. Well, at the end of the day, I'll tell you, we've got about 20 matters before the tax court. Now, it doesn't always work, right?
Well, the other thing is think about it this way, is that a lot of times the costs are going to the TCC after you go through CRA appeals. You're looking at $100,000.
Yeah.
And that's just your sunk cost. Will you ever recover it? Even if you're successful, you're not going to get, full indemnity for your fees. So that's one of the issues.
If I could make a law in Canada, Diane, you know what the law would be? It would be that every single tax advisor, whether it's insurance, investment advisor, anyone else who is an advisor, needs to argue a matter before the Tax Court of Canada and see what kind of problems people get into. They need to understand litigation, tax litigation, before they do planning. Because all of these ideas that are aggressive and people doing things that I wish they wouldn't do, things that are terribly, yeah, yeah. And so,
I know we're getting to the end here, but I do want to make one pitch here, a really big one. And that's where I think your family office can come in. I'm certain of it. Is that I've been dealing with a major CA firm here in Canada. We do a lot of tax litigation together, a lot. Very serious, very high-end. One of the things we find is the lack of documentation. Documentation is crucial. You mentioned minute books. When you think about it in Ontario, I think you got to have a real estate ledger in your minute book, talking about your real estate interests. You've got to have corporate transparency, BC, Quebec, Ontario, with respect to the shareholders, directors, and so forth. These things have got to be kept up to date. And, they're ripe and easy pickings for the CRA. So when you go in and tell them, listen, I remember exactly what I did on such and such a day, I might not have written it down. Can you say the same thing about your minute book? So, you know what? My view always is put pen to paper, spend the time, because at the end of the day, you may well need it. And it's not something you should do 2 years afterwards. Because as you know, in the law of evidence, you want to do something, you want to make sure that your note taking is contemporaneous with what you did. Again, I think it's really important, Todd. I can't emphasize that enough, that we're seeing lack or inadequate documentation as a major stumbling block in successfully litigating a tax file, or any file for that matter.
Yeah, oral testimony is only worth the paper it's written on, if that's all it is. Right?
Very good. I like that.
So contemporaneous documentation is critical. Documentation that's created during the time that the events take place. Going back and changing documents. There's technology that CRA would use to determine when things were signed, as an example.
Well, you'd never do that anyway.
Yeah. No. Yeah, right.
But
Exactly.
I think, Todd, the key thing is that you're in a position to help clients do that.
Yeah, exactly.
Not to change it, but to do it contemporaneously and accurately.
There's many things that aren't documented that need to be, right? And
Right.
it's true. Anyway, I think we've kind of come to 25 minutes after the hour, which I believe our target was to finish our questions by 1:15. So
Yep.
perhaps our additional comments took us past. But we have a lot of fun doing it, right? So we love tax, we love solving problems and corporate structures and things like that. So anyway, it's been a lot of fun. Thank you, everyone in attendance.
Thanks, all.
Thank you, Diane. Thank you, Andy. Thank you.
Thanks, Todd, Andy, and Jordan.
Thank you, everyone.
Thank you. Bye-bye.
Bye now.